I'm really excited to kick off our second day of spokes with the chairman of Californians for Consumer Privacy, and really the force behind the California privacy laws passed in the last few years, Alastair Mactaggart. So Alastair, welcome to our virtual stage today. And great to see you here again.
Hi, how are you?
Good, good. Well, we have as usual a pretty significant crowd here today, Alastair, and the California laws, now plural, were the subject of a lot of different discussions yesterday. I'll just, a couple things to just start the conversation. When I was just doing a little prep over the last few days on what's been in the news recently, Alastair, if you just search CCPA, CPRA on the major search engines, something like 120 million things come up on just a general purpose search, and an equal number when you search for news. It's a pretty amazing thing. Maybe what I thought I'd start with, just to sort of catch up our community here a bit, is since I saw you last, and I was checking this morning, there are now 26 different states that are all considering some version of what folks are calling copycats of the two California laws. Some of them kind of mimic CCPA, some of them mimic the combination of CCPA and CPRA. Just to keep it interesting for private sector at this point, and you are a private sector guy, Alastair, those 26, they aren't exactly identical. So even between the first two that we're really seeing, California, Virginia, and maybe now Colorado coming down the bend, there are differences between those three. And a lot of those differences actually even affect what is shown to a consumer. So you end up with, confusion or worries about like what the human beings at the end of the day are going to see. So first of all, I'll ask you, what do you think about the fact that there's this sweeping kind of momentum behind all of these different state laws? And then I'll ask you in a moment what you think about the challenges it's presenting with the differences between them.
Well, first of all, I think, this would never have been possible in California if it wasn't, an idea that's kind of broadly, I think, embraced by the general population, by humans around the world. I think people are increasingly concerned at the notion of being constantly surveilled. And there's, it's a funny thing in this country, if, I always say that if the government were to do what corporations do all the time, people would be up in arms. And so I think, all that California did, is, as it often does, is it provided a kind of a place to get the ball rolling. And I think all these other states are just reflecting, this deeply held belief among Americans that a lot of these practices have gone too far. So, I guess I'm gratified at one level that, other states are doing this. I do think the devil is in the details. I mean, it's not quite as, I'm not quite as rosy colored glasses about, look, this is great. All these 26, 27 states are going to, have great coverage. So first of all, I think you have to step back and say the devil's in the details here, because the regulations on CPRA haven't yet been done. And we can talk about, if you want in a little bit, but it's to me still pretty amazing how many corporations are really trying to, comply potentially with the letter of the law, but really just try to evade the purpose of it or the intent of it. So I'm consistently amazed at how difficult it is to find the privacy rights that are supposed to be there very, clearly here in California. But, going back to some of those states, like look at Virginia, right? So to opt out, you actually have to send in, you have to do it yourself. You can't do an agent. You have to send in some kind of a potentially an authenticated request. No one's going to do that. One of the great, I think, benefits of California is that it allows for my device, my global setting, my phone, my computer to do it for me. And I've always said, look, privacy is widely believed in, but once you kind of erect hurdles, people are like, I'm too busy. I got to do I got to go on, move on with my life. So I think that there is and I've heard from people in the industry, look, our strategy is to get a bunch of different laws passed that are weaker and then go to Congress and say, look, we have mayhem, we have confusion. But here, by the way, is the prevailing standard. So let's go with this standard. Those crazy people in California, don't deal with them, and sort of get this thing that looks like privacy, but actually doesn't do very much. So I'm not super sanguine about like, oh, because there are other state legislation, this means necessarily that there will be good legislation. So I'll stop talking there.
Well, no, but a lot to follow up on there. But let me say, we have a lot of folks here. There were a lot of questions we've seen come up on panels. Hey, we should ask Alastair about this. So I will say, for folks attending today, if you do have questions that you'd like to run by Alastair, post them in the Q&A, and we'll take them as we go, because I'm sure we'd love to actually chat about this and cover things that are on your minds, either what was intended or where does Alastair see this going. So please feel free to ask those. So Alastair, when I would love to, I think a lot of us would like to hear from your perspective that color. So you're seeing some companies actually trying to do the minimal amount or fight against the next version of regulation. Do you have any color you can put on that? Like, we do see a lot from industry of trying to comply with different versions of this, and there are a lot of different technical studies on user experience to be able to show people the information the right way, just in time, without too much information, which also can be a bit overwhelming.
Sure. I mean, I think once the CPRA regulations go into effect, these cookie walls will sort of disappear, because right now they're super annoying. They come up, we're going to, collect your information, you consent, and, then you have to kind of walk through the different variations of what you want to consent. And really, if they're selling your information, there should be a do not sell my information button. Pure and simple, do not sell or share my information. And that's what should be there, and it shouldn't be complicated. And then also I should be able to set my phone or my browser and have it do it for me. So I think that's, I think California is a work in progress as well, just because these regs have yet to be written on this new law. And I think really I know why it happened the way it happened, why we did CCPA first and CPRA, and I'm pleased that the ultimate product of CPRA, I think, is a much better law than CCPA and much more comprehensive. A lot of the state legislation has been modeled on CCPA, and it's sort of like, well, that's V1.0, but 2.0 is much, I think, better. So, my hope is that some of the legislators who are doing this look at CPRA. But I will say there's those, industry is pushing back. So I was pretty involved in trying to help out some people in Florida, try to pass some laws. And it was, the full scale opposition from industry to try to, because they were trying to get a bit of a copycat for CPRA. And it ultimately didn't work. But it was, there were some really interesting legislators who were pushing for it. And I don't think it's gone away. So my hope is that there are some other big states that get good. Maybe New York gets good, good legislation, and we'll see. And then kind of getting back to one of your original comments, and I've said this before in lots of venues, I don't see that because states have different legislation, it's this fatal, end of the republic kind of situation. I can point to tons of different industries where, whether it's, liquor licensing, or whether it's, hospital regulations, there's lots of areas of our economy, employment law, where the states remain supreme. And so I think in general, this will be different flavors, but in my ideal world, what people want is not so different, whether it's in Europe or here or Japan. They want to know what information has been collected about them. They want to be able to stop it going where they don't want it to go. They want to be able to delete it. They want to have control, and they don't want to be the product. And so I think that within the context of those kind of broad basic privacy rights, if one state says you have to respond to a request within 45 days, and another state says you have to respond to a request within 60 days, it's not fatal.
Yeah, no, that makes a lot of sense. Well, and do you mind giving us, from your perspective, an update for everybody on, we now have a California Privacy Protection Board. We have a chair. They've started releasing agendas. They've at least started the process, as far as we can tell from the outside. Can you give everybody an update from your perspective? I mean, again, the law now takes a life of its own, right? It's not really the Alastair Mactaggart, it's run by a board and it's an independent. So can you just give us an update from your perspective? What's happened and even your insights into the new chair, who obviously is going to have a big influence on what happens.
Sure. I think you're right. I'm just citizen. I'm Joe Citizen now. So this is I'm just happened to this is my office anyway. Hi. There's my artwork by my son up there. Anyway, I think I'm just Joe Citizen, and but from my perspective, the board's been constituted. It's held its first meeting. The way we wrote it is it's not a full-time board, in terms of paid board, and I think that was kind of intentional. At least it was intentional because the sense is I think that the administration is where the point of the spear is going to be. So clearly, their most important job is going to be hiring the executive director that they choose to hire, and so that process will be interesting. And then they also get to choose the auditor. And then who else they hire, who they hire for that administration will be very important. And that's kind of, and then it's oversight, and I think it'll be the sort of traditional, probably approving settlements and approving, investigations. But honestly, they haven't written their bylaws yet, so they're kind of creating their path as they go, and it's a monumental task. And my hat's off. The chair, Jennifer Urban, I've known her for a while, been on some panels with her, and she's got a big task in front of her, as do the other board members. I'm pretty familiar with Lydia De La Torre because she's a privacy professor down at Santa Clara Law School, and over the years I'd gone down and taught at some of her classes, and she's great. She's an expert in not just American privacy law, but also in European privacy law, which is really a wonderful thing to have on the board. And so, I think it's going to be a lot of work. As you know, the draft regulations are due next July 1st, and a year will go by quickly, and especially when you have to, release them and get the feedback and all the rest of it.
Yeah, and one of the regulations that obviously is built into CPRA, Alastair, is this concept of issuing regulations around how a business will actually have to submit to the agency on a regular basis a risk assessment with respect to their processing of personal information. It's almost in the vein of like the European model. You file you prepare internal privacy assessments and a certification or something back, to the California agency. Can you talk a little bit about what you think was intended there, or where do you think that'll go?
Well, in my mind, the first time around at CCPA, that my fear was like it's brand new in this state, and so I kind of intentionally set the bar what I thought was very achievable, and that in a way that industry couldn't. I thought we were going to be going to an election in November of 2018, so I was like, let's have a very kind of muted set of rights. And then actually, when we did the deal with the legislature, it got better. So the original draft initiative that we got the signatures for in 2018 didn't have the right to delete your information, didn't have the right to see your actual information, right? So that was one thing, and we got better, I think, with CCPA. But then when it came time to do another one, if we're going to do another one, it's sort of like, well, let's do, what I think of as best in class. And so we just, there's so much of it. Anybody who knows about, the European, GDPR, this is. In many respects, many of the important principles are drawn from that. The limitation on geo-tracking, the limitation, the new creation of a new category of sensitive personal information, the board, the new agency with the guaranteed funding. These are things that just, I think, make it much better. And so your point about the certification or the sort of self, these reports that are required to be produced, those are good ideas. There's no pride of ownership here that they came from Europe, and they're good ideas.
Well, so we have a couple of questions that have come in, Alastair. Let me run a couple by you. One from our audience. Do you think privacy agents who represent consumers, kind of making the requests or filing them, do they help or hurt businesses who are complying with CCPA, CPRA? And then should they be regulated like data brokers just to make sure they don't somehow defraud consumers? In other words, you could end up with somebody asking for data who's doing it fraudulently, or is effectively acting as an agent to opt somebody out where they weren't. Do you have a view on that?
We say, registered with the state, and we assume there will be some certification processes. Again, it's a really bad outcome if this thing becomes a vector for fraud. So we expect, and that's why even within the context of CPRA, there's one threshold for opting out, because there's no real public policy disaster if I pretend to be you and opt out. And there's a much higher threshold for, getting access to your data, for deleting your data. And that's intentional. And so again, if someone can pretend to be an authorized agent and get my data, it's not good, right? So we expect there to be, the regulations would be restrictive around that. But I think, in terms of the agent, I keep on coming back to my vision for this is that it's got to be simple for people to do it. If it's easy, people will take advantage of it. And if it's complicated, then the industry that revolves around buying and selling your data will win. And so I feel like it's got to be easy. And I do think we have set up the framework, so the regulations should support that. And I do think that we've created or helped create privacy industry, that both for helping businesses comply and for helping consumers take advantage of their rights. And by the way, I think that's going to be just good for business. I think there's so much general apoplexy about, oh my God, new regulations, but clearly this is something people want. Transition is always difficult, but at the end of the day, I'm convinced people will look back on this era of sort of before there was any privacy regulation in sort of horror and say, gosh, can you imagine that they used to be able to, track me 24/7 and sell all my data? It's really, I think it's not, we will look back on somewhat askance on this era.
Yeah, let me just say, from almost everybody here, I think most people still see this as a movement that's going to move. It's going to move, but it takes time. Right. I still don't think most people feel like they have any good understanding of what happens to their data when they do business with somebody or even visit a website. I still think we're pretty far off, but it is a significant move, in my view, Alastair, to start having at least some standards around this that people can react to in a much easier way. But I was reading between the lines a little bit earlier on, and this is also in one of the questions we received, that it sounds like you would be worried about a federal law, in terms of what it would pass. And in other words, if I'm guessing, you're worried or skeptical that if there were a federal law, that it would set the bar high enough with enough meaningful parts to it. Is that right? Would it have to mirror California in your view to be high enough, or what would a federal law that you would feel comfortable look like? What are the meaningful parts to you?
I like many Americans, I think I'm saddened by sort of how hard it seems to be to get things done in Washington right now, and how much, if mask wearing becomes a political fight when it's pretty clear that was supposed to save lives, it's you start to think that everything becomes a political fight, right? And so I do think this is one of where the republic works, the states work. Sure. Yes, if there was a great federal law, that the problem is, how do you change it? If it's something bad gets into legislation, we've seen, 1986, the last 35 years, any police, agency has been able to go get your stored, communications over 180 days old, and everybody thinks that's a bad idea, and yet that's still the case. It can't get changed in Congress. So I feel like I'm not holding my breath on legislation in Washington. Anything's possible. I think that the problem and the opportunity right now is that privacy is a moving target, and will be and should be, because technology is moving. And if you have one law that just sits there, and that's why we purposely built in the ability to change this law in California with a simple majority of the legislature, albeit not in a way that's less privacy protective, but in order to move with the times, we built in that flexibility. We didn't sort of say, okay, this can never be changed. It's the latest and greatest and forevermore shall be. It was overtly designed to be changed by the legislature with a simple majority. And, I think, and people have heard me say this before, it's pick an area of law, antitrust, environmental, these things change over time. And where I would say is this is a good first step. We now have 1 in 8 Americans that I think have really good privacy coverage, but come back to space in 10 years, 20 years, 30 years, it's going to look radically different, and it should, and it will have to. So that's what I would say.
Yeah, no, I mean, and you were referring earlier to Akpa Alistair, which is a law that I think a lot of folks haven't heard about, the electronic communication.
You were the one who told me about it the first time. I couldn't believe it, but you should tell people about it in case they haven't.
Yeah, no, I mean, I'll just be brief about it, but it's a law from the 1980s, and it was passed when, mail providers that you can think of from the 1980s, they didn't have a ton of storage. And so at the time, there was an assumption that if you left your email on your email server, like a third-party server, for more than 180 days, that you've given up any expectation of privacy. It became like a business record, like a check. And so the government has the right under ECPA by the statute to actually go directly to your email provider without a warrant and get your emails if they're on one of your email providers for more than 180 days. I have never mentioned that law to anybody whose face doesn't look like yours does right now, Alastair. Everybody on the Hill that we have talked to also has the same shocked look, because people view their email like you view mail. Nobody views themselves as waiving privacy, but that law has not been able to be changed it's been challenged for a very, very long time with 90%, 95 approval ratings to change the law. So I think it's a point.
Twice it passed out of the House of Representatives unanimously. What was the last piece of legislation? And twice it got held up in the Senate. I mean, it's crazy, right? So you put a blanket privacy law, omnibus privacy law in for the country. Does it sit there like a wet blanket for the next 35, 40 years? That's my worry about any, frankly, federal legislation in very rapidly moving technological area. So even look at Section 230, how much angst is like worrying about like that and its sort of its impact on the space. And so I don't know. I feel like the state legislation here is the right way to go.
So and then I'm going to pivot for a moment and we'll come back to some other questions. They're still coming in. I'm going to pivot back for a moment, Alastair, to the international stage, if I may, for a moment. So Bruno J Corelli, the lead for the International Data Transfer Unit, is actually speaking here as our closing keynote today, and you know Bruno well. There was a significant decision, as you know, last year from the European High Court in Schrems, which struck down the Privacy Shield adequacy decision. And I wouldn't, without going into the weeds on that, because there's a lot written about it, the critical part of that may be relevant for you is because so much of that decision hinged on the national security parts of the adequacy finding, that affects in some ways California's ability to get adequacy for, under its new laws. So as far as I understand, you tell me your view too, California could be an adequate state because the European Union recognizes subsets of countries as potentially adequate. You now have your two laws, and obviously there would have to be a review by the Commission and the member states before it would happen. But just today, we've heard the European Union and the European Commission and the United States government are engaging very actively here following the summits in the last few weeks in Europe to get a new privacy shield and perhaps a new adequacy decision. Are you still thinking about adequacy as potential for California? And do you know if California has actually started any kind of process to perhaps engage on that? or are you waiting to see where, or waiting you and California? Are you sort of waiting to see where things go on the federal side?
Well, first off, I think my attitude has always been solve what you can solve. Obviously, a state can't solve a national security issue, but I've always believed that there's too much at stake between the two trading blocks for this national security issue to prevent data flowing. They will solve it, and they being, the administration, the Europeans. I just feel like, especially with, the vice president from California, who was attorney general, who was pretty involved with data security. I think we're going to get some kind of resolution there. There's too much at stake for there just all of a sudden be no more data flows between, North America and Europe. But then you still have the problem. Okay, well, what's the adequate data protection regime, right? So I do think there's a role for California to play, assuming that the national security issue gets solved. I think there is a role for California, and I'm pretty clear in my mind, and which is not always what's clear in everybody else's mind, but I think there's nothing in CPRA that would prevent it getting adequacy, and I think there's nothing, again, missing in CPRA that would prevent it getting adequacy. That doesn't mean it will get adequacy, because that's a political decision in Europe. But it's a one-way, it's not a constitutional issue for a state, because it's not like you're entering into a treaty. So it's possible, and I'm hopeful. So I think it's a logical step to take.
And do you know who? I don't even know if I know, but who would lead that for California? So let's say there is a new adequacy finding on Privacy Shield. Obviously, that is a very big deal. The adequacy finding in Privacy Shield would be very significant, because even setting aside adequacy for California, Alastair, right now companies are putting in either what are called, as you know, binding corporate rules to transfer data from Europe, which is very expensive, or there's an evolving sort of movement around standard contractual clauses. There was very recently new guidance out on that, and it puts there's some burdens on companies that are very hard. For example, for small, medium-sized companies who are trying to do the right thing to just do business in Europe or move the data. So, but that adequacy finding would help everybody, all of those different groups, including California. But if California decided, hey, I want to try to go seek adequacy, is it the new data protection agency that would lead that? Or do you know if that's part of what they would lead?
I think from what I've heard from the Europeans, they're, it's not like there's some magic, you need to have this authority. I mean, I think the administration could do it here. The governor's office could do it. I think the data protection authority could do it. Maybe when they hire the new CEO, he or she could do it. So I think it's just a matter of someone deciding to do it. I mean, things being what they are, I would imagine that the administration would kind of want to, be involved here in this state. So yeah, I don't think it's a, the important thing is having the legislation. And I think it's an opportune time, honestly, if you think about it from a perspective of, okay, we haven't written regulations yet, to the extent that the Europeans said, well, okay, we like everything except for, it's too long, to get your data back here, or it's too short, or this period is, there's the ability to write a regulation to kind of solve that, if assuming it doesn't go against the statute here. So, I'm hopeful that this will vault us into the first tier of privacy around the world, and would be an anchor for us for privacy in this country.
Well, look, I want to be respectful. I know you will have a deadline or time issue, Alastair. So we have a whole handful of questions, but I'll just bring up one or two more. Do you know how California thinks about letting its own consumers know that they have these rights? Are there awareness campaigns, like other than going to a site and being informed about it? Is that
great question? We do. The statute does devote some money from fines and awards to education campaigns, but certainly, yeah, I think probably the average Californian has no clue that this thing, out of the 40 million Californians, I think probably fewer than more are aware of the privacy rights. Though that's actually, when we did polling last year, it was interesting. Actually, people had heard of it. But I think it's an important thing. And I think that's one of the tasks of the agency.
So, and yeah, I'll do one last one, and it's based on some questions I'm seeing. So just step back for a moment and you see what consumers see when they come to websites. It's definitely changed as a result of the California law. No doubt there's almost everybody has a CCPA warning of some kind, but Alastair, I don't know if you've done this. Like, have you ever VPN'd into Europe and just used a search engine just to see what it's like? When you go and you use any of the major search engines and you're seeing what a European sees, there's a block of text that's probably 5 to 7 paragraphs long that comes up when you want to search that tries to show you all this information. And then you have to make choices like, what do I want to do? And it becomes hard for just a person to ingest that and understand it. So just standing back and looking at it, like, it's definitely made a difference. There are new rights. People are moving their companies in different directions. Larger companies that we're seeing are really taking efforts to make sure they understand what's happening with the data and that they're prepared to go through some version of an audit next year, which is a very big deal in the US if you think about how much coverage there is. From the consumer side, do you feel like we're making enough progress so that people in California or around the country really start to understand it better, in your view, like setting aside the law?
So where I would say is that if at the end of the day, what happens is this is a series of obstacles that companies that want to transact in your data have to leap over in order to keep on transacting your data. But at the end of the day, they're able to keep on doing what they were doing before. Just now that there are, you got to go to paragraph B and turn around 3 times and, tell the consumer X, Y, and Z. But in general, 98% of people still do the same thing because they've made it so difficult for people to kind of exercise their rights. Then I say we will have failed. And there's a risk of that, clearly. I feel like the effort will have succeeded if, in general, the industry that is currently trying to transact in your data ends up giving people really clear, easy, meaningful ways to stop that transaction in their data. And, again, we're pretty, if you think about our approach, I'm not anti-business, clearly, I'm a business person. We don't do a lot to restrict a first party's use of their data, because I've always felt like if you, the consumer, want to do business with company X and you're willing to give them your data, that's a kind of willing buyer, willing seller. What you want, though, is a situation where the person has some control over all that other stuff that they have going back to your comment that no one knows what's actually happening to their data right now. I shouldn't have to be able to fix a jet engine to get on a plane, and it should be safe. And I think that's kind of where I hope this goes. I don't have to fill out a whole bunch of stuff saying I know how the jet engine works before I get on the plane. I should be able to just be like, it's safe because the government inspects these airlines. And I kind of want my vision. That's what the internet would be. You go on a website and in general, the same way I know when I go on my phone that AT&T is not actually listening to my phone call and selling that data. Why, when I visit a website, should that data be sold? Or should I not at least be able to easily control that? And I think right now we're in a war. And by the way, there are lots of companies that are embracing the spirit of this. And so I don't want to say industry with quotes around it and say like everybody's bad, because they're not. And there are many companies whose business is not buying and selling people's information. They're trying to deliver a product. And then there are many companies whose businesses are tracking me ubiquitously forever, always trying to know as much about me as possible. And I think that I'd like some rights around that.
Alastair, that's a perfect way to end. I will say we got a lot of questions around the adequacy and collection. I will say Bruno's here later on today, and well, how about we'll save some of these questions. We'll ask him too for his view on adequacy and where things are with the Privacy Shield negotiations and that adequacy determination. As always, great to see Alastair. I'm really hoping we can actually catch up in person at one of these events sometime soon. And on behalf of all of us, thank you for all you're doing. And hope we see you back soon.
All right. Bye-bye.
Thank you. So, Stephen, over to you. Take us into the next session, and I'll see you later for a session later today.